Good afternoon, everyone. Thank you so much for joining us today for the 2023 NASW New York City Social Work Month Series event, Family Regulation and Reproductive Rights in a Post-Dobbs World with the ACLU of New York and JMAC-for-Families. Just a few items before I hand it over to today's hosts. My name is Angelique Imani Rodriguez. I'm the Manager of Community Engagement and Volunteer Initiatives here at the NASW New York City chapter. I coordinate, organize, and facilitate a lot of the free community engagement events like the Social Work Month series and more here at the chapter. I'll try to be as quick as I can because I know there's tons of information being shared. I want to maximize your time with our host today. If you are having any technical issues with audio or visual, please message me in the chat and I'll be happy to assist. Please remain muted during the presentation until the hosts ask you to unmute your mics. Post-event, an email will be sent to all attendees with the recording of today's event, information on how to get involved with the chapter, membership info, information from today's networking forum. Don't worry, I'll drop that link in for the form in the chat shortly, and any materials approved by our hosts to send your way. We hope that when registering, you opted to join the NASW New York City email list, which gives you access to all of our updates, news, and upcoming opportunities. So what's coming up at the chapter? Our last event of the 2023 Social Work Month series is the NASW New York City Town Hall Luncheon on March 31st, where you'll get to meet chapter staff and hear about the work we do here at the chapter and further ways to get involved and engaged with us. In April, we're having a new Self-Care for Social Workers series at the start of the month. This self-care series is a member exclusive item, so if interested, make sure your membership is active and you're logged into the website so you have access to the schedule. And during the last week of April, we are holding our Spring 2023 Senior Series, which is a set of events focusing on topics around seniors and working with seniors. In addition to that, Currents, the biannual chapter newsletter, has reopened for submissions. And yes, we do accept submissions from students. And of course, applications for our student liaison program, the NASW New York City Cares Member Ambassador Program, as well as our NASW New York City Cares Mentors Program reopens for the next round in May. Last but not least, registration for the NASW New York City Virtual CE Conference is open. You can earn up to 9 CE contact hours during our 2-day virtual conference. During Social Work Month, we are offering an early bird discount until March 31st, so we encourage you to invest in yourself today. If you don't need the CE contact hours, but still want to engage with the conference, the chapter is currently seeking volunteers to support the event with opportunities to engage with leading social work professionals and get highlighted in our Spring/Summer 2023 issue of Currents. If your organization or school is interested, we also have sponsorship opportunities as well as discounted group registration rates. I know that was a lot of information, but as I mentioned before, all of this information about how you can get involved and engage with the NASW New York City chapter will be included in your post-event email, along with everything shared during today's event. Expect that email to be sent sometime tomorrow. Just keep your eyes open for that. If you have any questions, I'll drop my email in the chat for you all shortly. Once again, thank you all for joining us today. Without further ado, it is an absolute honor to introduce the host for today's event, Jenna Lauder from the ACLU of New York, and Jasmine Wali, MSW from JMAC-for-Families. Ladies, whenever you're ready.
Thank you so much, and thank you for having us today. We have a lot to share, so I think we'll just jump right in. I see Jasmine has already shared her screen. We're here today to talk about two issues that we really view as being very interconnected. So we want to talk about both reproductive rights and abortion access after Dobbs, as well as family regulation, and really highlight the ways that these two issues are connected on the spectrum of reproductive justice. So to start us off, I think it makes sense to situate ourselves in this present moment. As you all certainly know, last June, the Supreme Court overruled Roe v. Wade, taking away a right that we held in this country for roughly 50 years. It's important to understand that Roe was always a floor, not a ceiling. And so under it, abortion access was still a fiction for many people who couldn't access it due to finances, stigma, and even, restrictive laws that were still permissible under Roe. But without the baseline assurance that Roe provided, reproductive rights, as you've all seen, have become even more inaccessible. So at this point, nearly half the states are poised to either completely ban abortion or have already done so. Nationwide, at least 66 clinics have stopped providing abortion care since the Dobbs decision, and 26 clinics have shut down completely, depriving people of other, really essential reproductive health care. At the same time, you all might be aware that there is this looming court case out of Texas, AHM v. FDA, in which anti-abortion extremists have asked a hyper-conservative Trump-appointed judge to order the FDA to revoke its approval of mifepristone, which is a drug that's been safely and effectively used in medication abortions for over 20 years. And just to put that in perspective, this drug has been found to be even safer than Tylenol. So, to be very clear, abortion is and will remain legal in New York, but this decision out of Texas would affect all 50 states and seems likely to restrict access to one of the most commonly used forms of abortion care. Mifepristone is used in more than half of abortions nationwide. So this would be another seismic shift in an already extremely compromised landscape. And we are waiting to see the decision handed down by the judge any day now. So Jasmine, I'll pass it to you to say a little bit more about how this relates to family policing.
Sure, and thanks everyone for having me. I'm Jasmine Wali, I work at JMAC and we'll use terms like family regulation and family policing to describe the child welfare system. We use terms like this because people who've been impacted by this system have kind of led the vocabulary change in a direction that more accurately describes what this system does and how this system impacts families. And so, to Jenna's point, abortion access is really also an economic issue. It's not only about, bodily autonomy and what we always talk about, but it's also deeply an economic issue. There was a amicus brief filed by 154 economists, December of 2021, I believe. And they detail that, there's a causal relationship between denying abortion and poverty, right? So when you deny someone abortion, you are pushing them into, circumstances that can, that increase their risk of poverty. So directly, there's a, direct link between being denied an abortion and an increased financial distress and reduced credit access. Once somebody gives birth, there is an immediate and persistent 1/3 drop in expected lifetime earnings and they are more likely to stay in abusive relationships. And when we think about this in the context of family policing, family regulation, poverty is the leading reason that families get reported, investigated, and separated. In fact, families living below the poverty line are 22 times more likely to be involved in this system. And so, a lot of the rhetoric that I think that I saw post-Dobbs was, what are we going to do about all these kids in foster care, right? Are you really pro-life if you don't care about these kids in foster care or these kids waiting for abortion? And I think that link is actually really, deeply misunderstood. And, as social workers, it's our kind of duty to be mindful of the ways that denying someone an abortion pushes them into poverty, and poverty is why we're separating these families. And so I'll pass it back to you, Jenna.
Thanks, Jasmine. Yeah, so, just to ground us in some more definitions here, we're trying to articulate here how abortion is and, in some ways is not connected to family policing on the spectrum of reproductive justice. And we want to be clear about what we mean by that. This is a term defined by SisterSong as the human right to maintain personal bodily autonomy, have children, not have children, and parent the children we have in safe and sustainable communities. So what, Jasmine is pointing out is that both abortion bans and family policing are disproportionately harming people who are already most marginalized at that intersection of race, gender, and poverty, and kind of working in concert to deny people their human right to determine their reproductive future. So for the rest of this presentation, we're going to focus on what New York is doing to further the goals of reproductive and family justice by protecting and expanding access to abortion here in New York and combating family separation and surveillance by the family regulation system. So I'll just start us off with a little bit of background. New York has long been and held itself out as a leader when it comes to abortion access. New York legalized abortion in 1970, 3 years before Roe became the law of the land. And at that time, the state put up billboards at its borders advertising that abortion was safe, legal, and accessible here. Many, many years later, anticipating the fall of Roe, advocates pushed for passage of the Reproductive Health Act in 2019, which removed finally the vestiges of abortion from the criminal code and formally codified abortion as healthcare within the state's public health law where it belongs. The RHA also helped to expand abortion access by making clear that advanced practice clinicians, so nurse practitioners, physician's assistants, licensed midwives, can also provide abortion care when it's within their scope of practice. More recently, the New York State Department of Health also put out guidance clarifying that under the RHA, minors can consent to their own abortion care. And New York, I think just last year, expanded its insurance coverage requirements for abortion, where Medicaid in New York had long covered abortion care. The legislature now requires that private insurers also cover abortion care without a copay or deductible. So a major, step towards making abortion financially accessible to folks here in New York. So, we saw Dobbs coming for, a while, and, had started to push for a really concrete way that we could incorporate the right to abortion in New York State's body of law, with the possibility of a federal assault on the right to abortion in mind. So the NYCLU, where I work, had been deeply involved in pushing for an equal rights amendment to the New York State Constitution. And when Dobbs came down, it really made clear to a lot of people that if our rights aren't explicitly written down, they're very easy to take away. And so in the days immediately following Dobbs, the governor called the legislature to an emergency session in order to pass the Equal Rights Amendment that would enshrine reproductive rights as a matter of equality and anti-discrimination in New York's Constitution. Many of you may be familiar with an ERA, a federal ERA. This is not that. This ERA is very intentionally intersectional and would not only protect abortion, but it would prohibit discrimination based on a person's ethnicity, national origin, age, disability, and sex, including sexual orientation, gender identity, gender expression, pregnancy, and pregnancy outcomes, which is what speaks to abortion. So in order to become law, the ERA has to pass in 2 consecutive legislative sessions, which it did earlier this year. The legislature passed it for a second time, and now it has to go before the voters for a referendum. So the ERA will be on your general election ballot in 2024. So make sure that you remember to turn that ballot over a year and a half from now and vote yes on the ERA. Also, during this period of sort of rapid response to the Dobbs decision, legislators passed a provider, patient, helper, and seeker protection package that aimed at shielding folks who are involved in abortion care here in New York from potential attempts by other states to subject them to criminalization or other forms of punishment. So what these laws do is they protect providers' licensure and prevent medical malpractice insurers here in New York from taking adverse action against a provider because they provided abortion care to a patient who traveled to New York from out of state. These protection laws also do what they can to shield providers, patients, helpers, and seekers from criminal prosecution by preventing New York law enforcement from cooperating with another state's investigation into abortion care lawfully provided here in New York, by preventing New York from arresting or extraditing someone because they provided, aided in, or received lawful care here in New York, and by prohibiting New York courts from issuing subpoenas in connection with a hostile state's proceeding related to abortion care, again, lawfully performed here in New York. So essentially what these laws aim to do is they aim to prevent the machinery of New York's law enforcement and courts from being used to help hostile states further their investigations or prosecutions of people who are involved in care within New York State. And I would just note, this is a very new and untested area of law. It's constantly evolving. And some of these protections are relatively experimental. So we need to really remain agile to see what does and doesn't work and see what new attacks come our way so that we can respond. So that's all that New York has done so far. There's a lot more work ahead to ensure that abortion access is meaningful and protected here. So funding is a critical piece here to turn a theoretical right into a really meaningful one. The NYCLU and other advocates are pushing the legislature to establish a reproductive freedom and equity fund in this year's budget, which would be a comprehensive, sustainable program that would invest in providers, abortion funds, and logistical support funds, really the whole ecosystem that makes access to care a reality. Additionally, expanding access to medication abortion on SUNY and CUNY campuses is important to help those students conveniently get the care they need while reducing pressure on nearby providers as we see an influx of patients coming from other states where abortion is now prohibited or severely restricted. And that is another provision that is coming up in conversations around the budget, which is supposed to pass at the end of this month. So we're hopeful that these provisions will become law in the next few days, if not weeks. Additionally, we spoke about those shield laws that aim to protect folks from prosecution by other states. And another piece of this that's really critical is data privacy protections to help keep information related to abortion out of the hands of hostile state prosecutors who could use it to criminalize or punish them. Lastly, New York needs to require hospitals to be transparent about the policy-based exclusions that prohibit them from offering certain categories of care. So when I say a policy-based exclusion, I mean a denial of care that's not based in medical science or hospital capacity, but rather on bureaucratic decision-making by the hospital administration. These exclusions are often shrouded in secrecy, and patients often don't know in advance whether they'll be able to obtain certain types of care, especially including care like abortion or miscarriage care. We are hoping that New York will pass a bill that would require hospitals to report their policy-based exclusions to the Department of Health, who could then publish that to make it available for the public to make informed decisions about where they go to seek care. So that was a lot all at once. And hopefully what that does is really impress on you that New York really does still have significant work to do to ensure access to abortion, even here where it is legal and protected. And similarly, we have a lot of work to do to protect the rights of those who decide to have children, both during pregnancy and as they raise their families. And I'll pass it to Jasmine to say a little bit more about how these issues of bodily autonomy with respect to abortion also translate into similar issues when it comes to bodily autonomy during pregnancy, and ultimately the ability to raise a family without being policed and separated. So Jasmine, I'll pass it back to you.
Thanks, Jenna. So, I think Jenna did a really amazing job at laying out, the issues of abortion access. And I think, obviously, abortion access matters to everybody. It's been publicized well in the news. There's been a lot of mainstream attention from, across races, across socioeconomic status, about these issues of bodily autonomy. And I also think it's important to highlight who is most immediately impacted by these bans, and seeing the links that this demographic has with the people who are most immediately impacted by family separation and family policing, because there's an overlap there, right? So there's a number of studies that show that the majority of people who are seeking abortions are low income. Most have just experienced a disruptive life event, right? So they're particularly quote unquote vulnerable to a situation and needing to not experience another economic consequence. People who are seeking abortion or who are unable to access abortions in a post-Roe world are likely uninsured, working in shift and low-wage, inflexible jobs, unable to go out of state due to travel, lack of childcare, and/or disability. And I really want to highlight this piece about the types of jobs that the majority of people who are unable to access abortions are working, right? Because if you all have worked with parents who are ensnared in the child welfare system, the majority of parents that I've worked with have these types of inflexible jobs. And you know, I've seen the trajectory of a case be really altered by the fact that this parent is working. They're unable to go to visits. They're unable to cancel out of work to go to court. They're unable to, you know, or else they lose their job, right? Which pushes them further into poverty. So there's really this overlap here of who's being most directly and immediately impacted. And the stories that we're choosing to tell instead is that, oh, well, these parents don't love their kids. These parents don't want their kids. These kids in foster care, they're unwanted, right? When in fact, when we look at the economic reasons for why families are in, you know, the foster care system, they mirror the reasons why families are choosing, you know, or looking to make the choice to not bring a child into the world. And that's not related to not being wanted. That's not related to not loving the child. It's related to, you know, this really economic decision of, can I, quite frankly, afford to bring this child into the world? And, you know, I was actually recently talking to a parent who, you know, didn't know she was pregnant, was smoking marijuana, and found out later that, you know, too late that she was pregnant, too late to obtain an abortion. So once she found out she couldn't get one, she, you know, stopped smoking. She, you know, started to change her life around the, you know, knowing that she was going to bring this child into the world, right? She came to the hospital to give birth. She had weed in her system, and the child was taken from her right at the hospital because the baby was drug tested without her consent. And so, you know, she had the stroller, the baby seat in the car. She had the baby bag ready to go. She had everything prepared at her home for this baby to come home. And the baby was taken from her. It's not that she didn't want the baby. It's not that she didn't love the baby, right? It's that she was unknowingly drug tested. She, you know, she didn't have the resources to fight this case. You know, so it actually segues well into this next topic that, you know, New York has been a quote unquote leader in, I think, abortion access or talking about abortion and protecting some rights of people who are seeking abortions, right? But New York, just like every other state, has a long history of criminalizing pregnancy and criminalizing people who are pregnant. And one of these examples is low-key, like secretly administering drug screens and tests to pregnant and perinatal people and their newborns without telling people what they're doing. So, you know, imagine you're in the midst of giving birth and your doctor is unknowingly not telling you that he's taking samples from you and testing this, right? That's a huge issue of bodily autonomy and violations that the general public doesn't really think about or doesn't really, you know, talk about, because the majority of people who are most impacted and most commonly tested are people who are seeking care from public hospitals or from hospitals that are serving, you know, families in low-income neighborhoods. And so, you know, once a test is administered, and if it comes back positive, they are then reported to the state central registry, even though it's not legally required. And so, here, Black women are tested and reported to agencies like ACS at a rate 10 times our white counterparts. And so, when you think about it with, I guess, common sense, what does this lead families to feel, right? If you're regularly going to the hospital and you are experiencing violations of bodily autonomy, how does that impact the way that you perceive this quote unquote helping institution? It really impacts the services that these families are comfortable seeking out. And so, we continue to see high rates of child removals in the same zip codes of high rates of Black maternal mortality. And studies have found that pregnant people disengage from prenatal care, fearing judgment by providers and reports to CPS. And this, the image here is actually a recent study that shows, that looked at Black women, using medical systems and found that this specific fear of child removal impacted whether or not they would receive care and where they would receive care. And the parent that I, spoke about earlier, told me that when she, had another baby at a later time, she was traveling, an hour and a half to a different hospital by bus, by transit, right? Just because she didn't feel safe in the hospital in her community, right? And so imagine being pregnant, right? And traveling an hour and a half just to feel safe one way, right? So hour and a half there, hour and a half back, just to feel safer, getting the medical care that we are all deserving of and that we are all, should be entitled to. And okay, so, one thing I'll also mention, just the trauma of this type of separation. We know how important that this time period right after birth is, right? Nursing, skin to skin contact, all these things are essential in a child's development. Hearing your parents' voice, right? These are all crucial in the way, in the attachment styles that we develop, in the way that we trust our parents, in the way that we trust, our doctors, and these all impact our lives forever. But we have a system right now that because our parent may test positive for a substance, we can be violently separated from them at the hospital, put in a foster home or put in a center, and our parents don't know where we are. I've had parents that call the police on ACS, that call the police on CPS because they can't find their baby. When a child is removed from the hospital, that parent is then at court a couple days later, sitting on hard, straight back court chairs, waiting for, their court date to hear where their child is, how they can get their child back, right? Days after giving birth. So the trauma that these families are experiencing as a result of our violations of bodily autonomy, are really, invisibilized, I think, and deserve the same amount of attention that we give to other violations of bodily autonomy. So one step towards, addressing some of these harms, and it, to be frank, it doesn't go far enough, and also, it is something, right? So this Informed Consent Act would require that healthcare providers obtain written and verbal informed consent before drug testing and screening pregnant and new parents and newborns, and require that a drug test or screen be given only if it falls within the scope of the medical care being provided to the person or the newborn. Right now we have a practice in which most low-income Black, Latino, Indigenous families' parents are just routinely tested, right? And this is not medically necessary. This isn't even legally required, but it's fallen into our standard operating practice. And so this bill would require that medical providers have a conversation, right? We're all about, medical care. Transparency is the most important tool, right? Communication is the most important tool in guaranteeing that you can, conduct a proper assessment. It's the most effective tool in ensuring that this patient comes back, right? If you're not building this trust, how can you ever assume that this patient will come back? So this conversation and this, written and verbal, discussion is one step towards mitigating these decades and these generations of distrust between patients and medical providers. Jenna, do you want to add anything on this?
I would just add, I think we'll talk a little bit later in the presentation about mandated reporting. And, these healthcare providers are essentially all mandated reporters. But there's a lot of confusion, I think, about what that requires of them. So first of all, I think it's critical, as Jasmine said, that no drug or alcohol test or screen is performed without the patient's informed consent for all of the reasons that you described. But even if and when a test does come back positive, the law is very clear that a positive toxicology result standing alone is not evidence of abuse or maltreatment and is not reason to report a family to the family regulation system. So, this is another area I think where a lot of education is needed to help healthcare providers understand that what they're doing is, one, not legally required, two, not legally permitted, and three, deeply harmful to the patients that they allegedly want to be helping. So I just want to drive those points home. So I can just jump in then to, talk a little bit more about how, once a family does have a child, how the system continues to, harass and police families as they raise their children, especially those who are Black, Brown, and low income. So Jasmine touched on this earlier, why we call this system family regulation or family policing. This is the term we use to describe what many other people know as the child welfare system or the child protective system. But we think it's important to use this terminology because, one, the system doesn't protect and doesn't improve the welfare of the vast majority of children. And the terminology of policing more closely reflects parents and families' experiences of the system as, one of surveillance and punishment rather than support. This system has deep roots in racism, tracing its origins all the way back to the era of chattel slavery. And that legacy continues to inform how it operates today. So you see this very starkly in the statistics. In New York City, 90% of the families that ACS investigates are Black or Brown. According to a recent New York Times article, Black families in New York are 7 times as likely as white families to be reported, and 13 times as likely to have their children removed as compared to white families. Nationwide, over 50%, so over half of Black children in this country will have their parents investigated for abuse or neglect. And those families are twice as likely as white families to be permanently separated. So, throughout the entire duration of this process, from, surveillance and drug testing during pregnancy, to reporting of families during childhood, to the outcome of family court cases and permanent separation, you just see these racial disparities over and over and over again. And in a recent report that was actually commissioned by ACS to do an evaluation of its, of its own staff and its own policies, this report revealed that ACS's own employees experience and describe their work as being harmful to Black families. So, this is widely documented, widely understood that this is a system that, is a harmful one, much more than it helps families, and that it disproportionately and perhaps even intentionally in some ways targets Black and Brown families, especially those who are low income. So Jasmine, I'll pass it back to you to talk a little bit more about what triggers these investigations.
Thanks. So, the majority of cases are for, reasons of neglect, which is often poverty, which is framed as neglect, or symptoms of poverty. So failure to provide transportation regularly to your child. And so the child misses a lot of school, that counts as, that can be reported as an educational neglect, report. a family is not able to find housing because, New York City has no affordable housing, right? So this can be constituting a neglect case too. And, I've actually talked to judges who have said that they will not grant a child back to their parent because the parent is living in a shelter, right? So there's that discretion, or there's that choice there too, right? So it's not only in who gets reported and how the report comes in, it's not only in how the parent gets investigated, it's also in the way that the family court judges are making their determination of whether or not to keep this child in foster care. And this judge that I'm referencing specifically said the only issue with the parent was that he was in a homeless shelter. There wasn't any charges of abuse. There wasn't any charges of neglect. His only issue is that he was low income, he was poor. So once a family gets kind of stuck in this system, it's really hard to get out of. And I mentioned that piece about the shift wage labor before, right? Because once you're in this system and you're having to show up to all these court dates and you're having to cancel out of work to make all these supervised visits, it's really hard to keep a job. The majority of parents I've worked with lost their jobs. Many face eviction. Many, experience emotional overwhelm and may, spiral into, habits that are not the most healthy for them, right? So there's all these kind of lasting consequences on parents. In fact, mothers who lose their children to the child welfare system, the family regulation system, are at 5 times more risk of avoidable mortality than mothers whose children, pass away. Mothers who lose their children to foster care are more likely to overdose. They're more likely to commit suicide, right? So there's all these mental health impacts on parents that are, that are really not talked about, and rightfully, we do talk about the impacts on children. The foster care to prison pipeline is well documented. And I'd even argue that the pipeline starts much before the actual incarceration, right? Because Joyce McMillan, she mentions this all the time. When you look at the parallels between how children are treated in foster care, they really mirror the ways that people are treated in prisons, right? You have children and adults moving their belongings in trash bags and pillowcases. You have people being served what they're supposed to eat at whatever time they're supposed to eat it. You have supervised visits. They use that same terminology. You have a probation period. You have people being removed from their whole environments, their whole families, right? I've been in group homes too, where the food is locked up, right? You're locking up food from children, right? So this prison type of mentality or this carceral mindset really starts sometimes, maybe if the child is removed from birth, when the child is born. So it's no wonder that, children who experience 5 or more placements are, 90% of those children end up in the juvenile justice system. The majority, a quarter of former foster youth experience homelessness. There was a study by the National Foster Youth Institute that found that 50% of people currently experiencing homelessness have also experienced foster care. Substance abuse is up, unemployment is up, PTSD is up, and only 3% of former foster youth graduate a 4-year college. So, real quick, we'll just get into a little bit of the progression of the case. So like Jenna mentioned, a report is made, often by a mandated reporter, sometimes by, a neighbor, a landlord, an ex-partner, someone on the street. Once the report is made, a CPS worker comes into the home, they investigate the family. The investigation includes checking all the cupboards, sometimes strip searching the kids, checking all the medicine cabinets, and implicit biases really impact this stage too. And I want y'all to just picture this scenario, okay? You walk into a NYCHA housing building in Brownsville, okay? You see on the top of the fridge, there's 5 liquor bottles, okay? And on the counter, you see a case of beer. And you know, on the table, you see some cigarettes, right? Some smoked cigarettes. So what assumptions or what judgments might you be making about this family? And what flags might be coming up of, maybe there's a substance abuse issue here, maybe not, I don't know. I'll keep an eye on it, right? Now imagine that you walk into a mansion or a nice home in Westchester. You see that they have a wine cellar. You see they have cigars on the table. Are you making the same judgment about that family and substance abuse that you would about the family in the NYCHA housing building in Brownsville, right? Typically we would think, oh, wine cellar, they have good taste, right? They know what they're doing. We don't have that same, you know, perception of parents who are using the same substances, right? Based on the location of this family and the socioeconomic status of this family. You know, implicit biases really impact this investigation process. Jenna, I'll pass to you.
Yeah, and I would just add, you know, first of all, on that point about the perception between different substances, I think you may have mentioned this when we were talking about drug testing during pregnancy, but, you know, rates of drug use between Black people and white people are pretty much comparable, and yet Black pregnant people are tested at some much higher rates than their white counterparts. And you see how, you know, there are all kinds of, you know, mommy blogs and communities talking about, you know, CBD use or cannabis use or, you know, other types of drugs while being a parent and how that might be beneficial to parenting. And there's sort of this open acknowledgement that, you know, certain types, white parents are not going to be punished for their use of these substances. While at the same time, you know, if you see a Black mother walking down the street and smoking marijuana in, you know, in Harlem, society takes a very different view of that activity. So just to, you know, really emphasize the point you were making, Jasmine, about how there's a ton of implicit bias in all of these perceptions of behavior. So also during the investigation, you know, we'll talk a little bit more about this, but this is a period when parents' rights are frequently violated. You know, families have a Fourth Amendment right to privacy in their homes, and ACS, even more than the police, often will completely bypass the legal process required to infringe on that person's privacy rights, and is often given, you know, a blank check basically to go into a home and, as Jasmine described, open cupboards, turn people's lives upside down. These investigations can last for up to 60 days. And during that period, it's possible that ACS will even remove the child suddenly on what they call an emergency basis. After those 60 days or after a child is removed, ACS has to then either close the investigation as unfounded or file a case against the parent in family court. Once a case is filed, it can stay open for years, and the child may either be placed outside their home or with the parent during all or part of this period. The parent may also be required to comply with what they call a service plan in order to have their case closed or to regain custody of their child. These services, they can be onerous and they can be unhelpful and really unrelated to the allegations against the parent. And when I say that they can be onerous, what I mean is, you know, they take up time that the parent needs to work to take care of other children if they have other children at home. It can, you know, take hours for them to travel across town to attend these services. They might have to take time off work that can jeopardize their, you know, stability of employment. So, you know, requiring parents to sort of jump through an endless progression of hoops where, as it's been described, you know, the target feels like it's constantly moving in order to regain custody of the child. That's sort of the Byzantine type of system that parents find themselves in when they are in family court. You know, when you get to sort of the end of this process, Ideally, it will result in reunification, but often it results in termination of parental rights. And under federal law, under the Adoption and Safe Families Act, if a child is in foster care for 15 out of the most recent 22 months, the state has to move to terminate those parental rights unless there's some compelling reason why adoption would not be in the best interest of the child. So what that means is that even if the parent has been making, their best efforts to comply with their service plan to regain custody of their child, and regardless of what the allegations were against the parent, even if it was, a poverty-related, relatively minor neglect issue, leaving the child unattended because they couldn't afford childcare, something of that nature, the state can and will still permanently sever the parent and child relationship. So this is, it's a really cruel system that inflicts significant trauma on the people that it ensnares, and can, permanently alter the trajectories of people's lives. So if we go to the next slide, we can see that, advocates are, of course, pushing for policy changes that can help really narrow the front door to reduce the number of families who are investigated and separated by the system. This system has its origins in racism. It is so designed to, it is not designed to give parents what they need. And so the best types of, intermediary reforms would be those that shrink the system and shrink the number of people who are harmed by it. So I can start by going through some of these reforms briefly, and then I'll pass it back to Jasmine. So, the first reform would be ending the practice of unauthorized drug testing and reporting that we discussed earlier. Second, we can reduce mandated reporting and reframe it as supporting. So think about what people in these helping professions, like social workers, like doctors, what they can do to support parents as opposed to just, reporting on them. It also includes ending anonymous reporting, which is currently allowed in New York and can lead to malicious and harassing reports. We're also advocating for legislation requiring CPS to tell parents their rights at the first point of contact so they can better protect their privacy when CPS comes to their door and don't, feel coerced and compelled to just, welcome them in with open arms. And I'll let Jasmine, I think, finish up this section as we transition into the next.
Sure. Ensuring that parents have access to counsel during an ACS investigation. So, this really starts right when the ACS worker knocks on the door. How can a parent, call for legal advice? How can this legal advice person in this hotline, support them through this very intense process? And also, ensuring that they have, quality representation during this prosecution process. And, all of this is really meant to narrow this front door and, reduce these unnecessary investigations. And, 85 to 89% of reports federally are unsubstantiated, right? So nearly 90% of all these calls and these reports and these, time consuming and stress inducing investigations are, found to be unsubstantiated. In New York, each investigation costs on average $6,000. So it's, when we think about how we can be better investing in families and how we can be better using this money and reducing, there's bipartisan support for more, efficient use of the budget, right? So when we look at this system, there's $6,000 being used per investigation, where 90% of these investigations are unsubstantiated, right? So what can we be investing in instead? So I want you all to just sit with that, question and think about ways to be increasing your advocacy. And we have a number of initiatives for next session. The Child and Family Wellbeing Act is one of them. There's, a number of initiatives to reinvest money into communities. But we also want to highlight the need to re-examine mandated reporting. And so right now, Jenna and I are part of a working group with an initiative with children's rights to research legislative strategies for changing mandated reporting laws in New York State. And We had a hearing that was scheduled by Assemblymember Hevesi about mandated reporting. It is rescheduled. We'll keep you all posted of when it gets rescheduled for. But we really encourage you all to come and share your experiences with mandated reporting, because, I've been a mandated reporter. I remember the training. I remember the stress, the feelings of liability, and, the fear for the consequences that could come if I don't report any suspicion of abuse or neglect, even if I know that report won't bring help in the way that this family really needs. So I encourage you all to think about ways that you can use your position in your advocacy to be pushing against this practice that, for decades has really not, has not had any evidence of preventing child abuse, has not had any evidence of preventing child fatality, right? But has really contributed to a system of harm. As JMAC for Families, we have an initiative to repeal CAPTA. CAPTA is the Child Abuse Prevention and Treatment Act, which federally codifies mandated reporting. We have a Twitter, so, at Repeal CAPTA, if you all want to follow along with what we're doing. And then this mandated supporting reframing that Jenna mentioned. And, us at JMAC for Families, we actually replaced the mandated reporter training that all Columbia School of Social Work students receive. So they will be trained in this mandated supporting framework.
So, we also mentioned that the NYCLU, JMAC for Families, and our partners, we support legislation that would end the practice of anonymous reporting. As I mentioned, currently anyone can call the state central register and, make a report completely anonymously, not even having to leave their name. What we would want is for the legislature to require a shift to a confidential model. So a person making a report would at least be required to leave their name, but that information would be kept confidential. So they should have that same assurance of privacy that they would have under the prior system, but there's just a small mechanism of accountability. And what this does is it deters people from making knowingly false and malicious reports that are designed to harass and intimidate people. Frequently, knowingly false reports are made by domestic abusers or during ongoing custody disputes as a mechanism to, really to terrorize a person. And it's a weaponization of this reporting system. And so by, leaving a name, we hope that will at least deter those, not only malicious, but also, reports that waste the time of the system and distract from any, actually legitimate reports to the extent that they are made. Jasmine, do you want to talk about Miranda?
Sure. I think we mentioned it, but Miranda would just require that ACS workers, CPS workers notify parents of their rights, provide information about the legal services that this family can call, and, really emphasize that this family has a Fourth Amendment protection against government workers, just like every other family. And to Jenna's point about the report by ACS themselves, I think this bill also really informs these ACS workers and these CPS workers that they have a responsibility to respect people's rights too. So to the point about the Fourth Amendment, right? This is not anything new. The Family Miranda Bill doesn't make any new rights. All it does is it informs people that they are also protected by the Fourth Amendment. And the Fourth Amendment lays out that government workers can legally only enter someone's home if they are invited in, if they have a court order, or if there are emergency circumstances. Meaning, maybe like a child is screaming, like there's a gunshot, right? There's an emergency situation in which this government worker has to intervene.
And I would just quickly add to that, parents, so these are essentially the same rights that people have in the criminal context, and hence the name that we've given this bill, the Family quote unquote Miranda Bill, because everybody knows that they have Miranda rights in the criminal context. The Supreme Court decided that, if people are not told their rights at this sort of pivotal moment, in the moment when the violation could occur and when they're faced with the coercive power of the state, not only can we not really expect people to be able to effectively assert those rights, but we also, we need those rights to be stated to remind the powerful government actors that they are also obligated to respect those rights. And so you really have the same dynamics in the family regulation system, where a parent is confronted by caseworkers. They are, frightened, maybe they're confused, and they don't even have the sort of popular understanding of what their rights are that they, you see in the criminal context in TV and movies all the time. You have the right to remain silent and all of that. And so people not knowing what their rights are, confronted by caseworkers saying things like, you need to let me in, or if you don't let me in, I will call the police and I will come back with the police. So really, taking advantage of a parent's lack of awareness of their rights. We of course can't expect people to be asserting them effectively. And you see this, I pasted an article in the chat, recent reporting by ProPublica and NBC News, which found that in 99.8% of home entries by ACS, they did not go to court to get an entry order like they're required to do. So in only 0.2% did they go through the formal process that the law requires them to. So it's a massive issue, and requiring ACS workers to tell parents their rights, we think is a step in the right direction. So I'll just quickly speed through this last one. Timely access to counsel is a critical need for people facing investigations. Currently in New York State, parents are entitled to court-appointed counsel. So what that means is, if they can't afford to hire their own lawyer, the court will appoint them a free lawyer to represent them. But they're only, that right is only triggered once they're in family court. So they have no right to an attorney during this whole possibly 60-day long investigation period, where, as we've said, their child could be taken away, their rights could be violated, their home is searched. And so we think it's critical that New York provide this access to counsel at that investigation phase. In New York City, there's already a pilot program where New York City family defense offices have been providing that timely representation, and it's shown to prevent the filing of a family court case in 75 to 80% of those cases, and prevent over 90% of children involved in those cases from entering the foster system. So it's really effective at, reducing, at mitigating the harms of this system and at keeping families together. It also levels the playing field. If a wealthy white family is reported to ACS, which is unusual, they will absolutely secure their own counsel because they can pay for it. And it's essential that we ensure that low-income families have access to that same support. So I realize we are very nearly out of time, and we just want to sort of tie all of this together by, coming back to this concept of reproductive justice as this unifying thread between reproductive rights and family policing and family integrity. Just to really impress on you all that these issues are interconnected. And even other intersecting issues that create the social conditions that make raising a family possible. So access to housing, to childcare, to a living wage, to nutritious food. These are all issues that, disproportionately affect people at that intersection of race, gender, and class, and which are absolutely central to furthering those goals, that human right of reproductive justice. Racism and misogyny have long informed our country's policy choices in these areas and have paved the way for the vicious abortion bans that we're seeing and for this family separation sort of pathway that we've highlighted. So it's really imperative that as we rally, as we should be, for reproductive rights after Dobbs, that we're simultaneously fighting against family surveillance and separation and the punishment of poverty. Jasmine, do you Okay, well, in that case, thank you so much. And I realize we're at time, but if anyone has, questions or wants to follow up with us, please feel free.
Awesome. I'm going to stop recording. Thank you all so much for joining us today. We appreciate your time. Jenna and Jasmine, of course, you're amazing. Thank you so much.